Hello, it's me again, the snarky juror. And this will probably be my last on this subject. I won't give it away if you want to know everything that happened. I've been gone most of the day. I've still got my chauffeur's hat on from taking the ex to his doctor's appointment. He had a stroke a couple years ago, so he can't drive. So I take him to his doctor's appointments. And I said, if I'm going to continue doing this, being your chauffeur, I deserve a hat. So he got me a chauffeur's hat. Anyway, I know what the verdict is. You probably do too by now because I'm not quite ahead of the game here. But let's discover things together if you want. Back in the corner. Sound is on. Oops. I got to do it this way.
Good question.
You are unmuted.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about due and thorough deliberations.
I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Giannetti?
Our view is that it's time for Tui Rodriguez. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. The previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We ask the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due and thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody?
This is what we discussed last time. I shared the tweet from Andrea Burkhart where she described what.
So why don't I take a recess?
Take a recess, please. All right.
And then Nancy.
Okay, she said something about why don't I take a recess until they get. There we go. Well, that's how it goes. "22 hours and 36 minutes.
Board of Session, please be seated.
All right. So, jurors, I am in receipt of your note. Judge Canoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please.
That didn't sound like a Thule thing to me. That didn't let them know that they have one more chance. I'm confused.
Thank you. All right, thank you.
You are muted. Goodbye.
That didn't sound like what I thought it was going to sound like. I don't know. As the jury deliberates for a final time. Well, I know that, but do they know that? It doesn't sound like they were going to send you back one more time. Sometimes I wish I was a lawyer so I could understand this stuff.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
I will voice my opinion afterwards.
Please rise for the jury.
Please get off the family. They've intimidated you.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
Thank you. Be seated. Closed session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
Please stop showing the family.
No, I'm just looking at my calendar.
Could we do the 22nd at 2 p.m., Your Honor? And I would appear from my client.
Right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
What about the 19th and 9th? Is that whole week?
no, that week's not good. The teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so the court knows, Ms. Little and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
We'd
Okay.
be proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not.
Okay. So you and your client will be here in person, Ms. Giannetti.
Yes.
All right. All right. Thank you. We'll see you then.
All rise.
I don't know where I saw it. Where did I see it? Paul O'Keefe allegedly said to Karen, "We're not done yet." Or words to that effect. That's the longest they've held there. And so it ends for now. For now. Find the right button, Susan. I do not agree at all. Trying to see where I might have seen. I don't know. I don't know. I believe it's a travesty. Mr. Botox prosecutor did his job well. His gaslighting during the entire trial, in my opinion, served its purpose. It hoodwinked part of the jury, so they couldn't come to the right conclusion, in my mind. The right conclusion being 2 professional, had no dog in the show, pony in the show, whatever that phrase is, said this damage was not caused by this body. And the damage on this body was not caused by this car. They did not meet. End of story. So what if she said, I hit him? Did I hit him? I could have hit him. I don't. She didn't know. When something just beyond comprehension happens, you go through a gambit of thoughts, emotions, fears, conclusions. You did your job, Lally. And you too, Judge. All the biased rulings that you did. You guys should be so proud of yourself. The real culprits, the ones that really did cause the life of Officer John O'Keefe, will not be tried, will not suffer for what they did. They're above it all, you know. That whole gang is above it all. The good old boys know the higher up good old boys, and everybody took care of the good old boys. Can't have anything besmirching them, inhibiting them from their little gang activity. Pin it on the girl. I feel sorry for the jury members who could not come to the not guilty conclusion, because someday they're going to realize how badly they were gaslighted, how badly they were hoodwinked. I feel sorry for them. I do not feel sorry for the O'Keefes. I did initially, but the more they glared at Karen Reed, the more they shook their heads. No, that's not a dog bite, even though 2 authorities said it was. Actually 3, because the coroner said it was possible in so many words. They refused to look anywhere else. They listened to the gang. They listened to the wrong people. I'm saddened. I'm extremely saddened and discouraged, disheartened. I hope the Commonwealth decides not to try this again. They have a year. That's my understanding. They have a year from today to either do a trial or make a decision to do a trial, a second trial. And I hope they don't. I hope half of them are in jail by then. I'm hoping that the FBI stuff that's going on behind the scenes, we're going to see a lot of bam, 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 people being taken down. I hope. But I have to tell you, I'm not very hopeful about it.
Welcome back to Court TV Live. I'm Julia Janae. Thanks so much for following along with us this afternoon.
Well, that shook me up good. Justice was not served today, in my opinion. I will, on the 22nd, bring whatever happens then. It's a status day. Don't know what that means, but we'll find out. So when I can, I will add updates. But as far as this goes, the snarky juror is going to be quiet for a while because I have no snark left. Only simmering anger. God bless Karen Reed and all who support her. God bless the O'Keefe family, and I pray the truth that gets revealed to them, because this does not bring justice to Officer John O'Keefe by blaming the wrong person. The truth of what happened to Officer John O'Keefe is still out there. It was hinted at during the trial, but there's no floor to go sample and examine for his blood. There's no basement floor. It was torn up. The house that it happened in is long gone. The dog who caused the dog bites, who knows where she is? We may never know now. And isn't that sad? We're going to call it here for now. I can't. I just can't. So until the next time we get together, wrong person, take care. And God bless.